afternoon, students. Today we start with a new topic, and that is the Juvenile Justice Act. This legislation also is very often asked for PYQs in multiple states, and therefore I've taken a cluster of questions, and I'm sure that the Rajasthan Judiciary aspirants will definitely take note of these questions because they are very important for them. So, without wasting time, we should start with this session. So, some of the questions that are asked in relation to this particular topic are direct. So, they are conceptual, and these concepts can be dealt with through the sections directly. And therefore, I suggest that you go through the Bear Act very, very carefully. In the first half itself, one of the most important topics that you deal with is the definition of child. Direct questions come on this. I have not provided them, but asking the age group is one of the most important questions in the Juvenile Justice Act because it is oriented towards dealing with children below a certain age for their protection and also for the purpose of their inquiry or assessment in case they have committed a crime and to bring them in front of the appropriate court or board. So, the age group is those who have not completed 18 years of age. I have provided the relevant section number. Another important aspect is the name or the term that is used for a person who has committed a crime and is below the age of 18 years. It has been mentioned as child in conflict with law. This is a transition, and if you look at the Juvenile Justice Act objectives also, one of the most important thing is not to in any way ostracize the child who has committed some kind of crime. So the terminology which is also used for them is supposed to be something which does not create any kind of negativity towards that particular child. So the name is child in conflict with law. Now, who is a child in conflict with law? Means who is either alleged to have or found to have committed an offense and who has not completed the age of 18 years on the date of commission of such offense. In short, it means that you must be below 18 years at the time of commission of an offense if the term child in conflict with law has to be used for you, right? And these are the individuals who are in a position to take the plea of juvenility, that they were children at the time of committing the crime. So, who are these individuals? Simply those who are below 18 years of age at the date of commission of crime. Now, another unique aspect of the Juvenile Justice Act is that it provides for general principles which must be followed when you are dealing with these children, right? And this is a unique perspective of the Act, and therefore, questions can come on it, right? Because it tells you how you must deal with these children, whether they are the ones who have committed crime or whether they are in need of care and protection, because these are another class of children who are protected under the Act. With all of them, there is an expectation that these principles are followed. What are the principles? The principle of presumption of innocence in the situation where they have committed a crime. You have to prove. The presumption is the child does not have the intent, the child is innocent, right? The principle of dignity and worth, the principle of participation, right? The principle of family responsibility, right? The family must take care of the child. The principle of safety, making sure the child is safe, taking positive measures for the child. Principle of ensuring there is no stigma with the child in case they have committed a crime, especially. So that is why you see that the terminology used is also of that nature, right? Principle of non waiver of rights. You cannot let them waiver their rights. Children cannot waiver their rights. That's also a protection given to them. Principle of equality and non discrimination. This is something which is in general we are very well aware of. Principle of right to privacy and confidentiality. We also know this aspect that we have to protect the identities of these kind of children. Even if we see cases which involve children in conflict with law, this particular principle is very well applied with. The principle of institutionalization as a measure of last resort. So, taking any kind of harsh measure with this type of children is the last resort. The principle of repatriation and restoration, to bring them back to their families, to restore them, is the primary agenda. The principle of fresh start is again interesting, that even if they commit some wrong, they are given a new slate and they are allowed to start afresh without their past history affecting them. The principle of diversion, this means that we do something different in order to achieve the objectives of protecting these children. So that is allowed under the act, that you divert from mainstream methods in order to protect the children. So, principles of natural justice and principles of ensuring the best interest of the child. So, generally, these are things we are aware of, but just to bear it in mind when you are actually reading through the act will help you. Questions can come on it, because, as I said, this can be a unique aspect which which the examiner might want to question you upon. Okay, so I have provided a question that has come on the principles themselves. You have been asked how many principles are mentioned under section 63 of the Juvenile Justice Act, and there are 16 principles that are mentioned to you. Do have a look at it, it can help you out with the exam. Now, another question that has been asked to you is: A is accused of having committed a crime on 1st January 2022. He attained the age of 16 at 31st March 2022, that is 2 months after the offense was committed or the crime was committed. On the date of hearing, he claimed that on the date of commission of the offense, he was a child. Which of the following statement is true? A can raise the plea of juvenility since he was a child at the date of the commission of the offense. B. A cannot be allowed to raise the plea of juvenility. C. For raising the plea of juvenility, the age of date of trial is concerned and not the age on the date of commission of offense. And D. All are true. Our answer is, of course, that A can raise the plea of juvenility since he was a child on the date of commission of offense. So, this is a little bit of a tricky question that they have provided, but it is on the emphasis of these two primary important definitions that you must be aware of. As I said, direct questions will come to you, but questions may come in this form and you must be able to answer that. He was a child at the time of commission of the offense because he just committed the offense 2 months prior to turning 16. So he was below 16 and therefore comes within the yardstick of a child and can take the plea of juvenility because he was a child at the date of commission of offense. Right? Now, moving towards one of the important questions that can come to you, another provision that has to be borne in mind is section 94. Now, it states that presumption and determination of age, where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provisions of this act, other than for the purpose of giving evidence that the said person is a child, the committee or the board shall record such observation stating the age of the child as nearly as may be and proceed with the inquiry under section 14 or section 36 as the case may be, without waiting for further confirmation of the age. Right, so where they feel that the child is appearing of a certain age and they are quite sure that it is a person who is a child, they can record those observations and proceed towards inquiry without waiting for confirmation of age. In case the committee of the board has reasonable grounds of doubt regarding whether the person brought before it is a child or not, the committee or the board, as the case may be, shall undertake the process of age determination. So, where they have doubts in their mind, they will do a process of trying to understand the age of the child. And how do they do it? By obtaining either the date of birth certificate from the school or the matriculation or equivalent certificate from the examination board. If that is not available, you will take the birth of certificate either from the corporation or the municipal authority or panchayat. And if these two are not available, then you can take the ossification test or any other test for the medical age examination of the child, age determination of the child. And this age will be recorded by the committee or the board to be the age of such person. For the purpose of this act, it will be considered the true age of this person. Now, why is this an important section? It's one of the critical aspects in context of determining whether this person is a child or not, and that will decide whether they will get the protections of this act, right? So where it is quite clear, the legislation has provided the process that is in the first half. In the second half, where there is a doubt, they have mentioned the documents which can be used in order to ascertain the age of the individual or determine the age of the individual. And the hierarchy of these documents are very clearly mentioned. And this is where you are asked a question. So, subsection 2 is actually your most important aspect of this particular section. Actually, the whole section is important, but in context of where there is a doubt in the age of the child, determining on the basis of documents can be a question that is asked to you. So, I have taken one sample question. While assessing the age of a person under the JJ Act, the court board is required to consider the documents in the following order of preference: birth certificate, birth certificate issued by municipality or birth certificate issued from school, matriculation certificate, ossification test, Aadhaar card. We know this has not been mentioned in the section at all. Yes, these three have been mentioned, but the order goes as: first, you will try to get something from the school or a matriculation certificate as provided in the first provision. Second, from the municipality. And third is the ossification test, right? So the order is relevant. Look at the provision, remember the order and the type of certificates that have been asked for or the medical test that has been asked for in that situation. Additionally, another question always comes in relation to the medical test which is mentioned under the Juvenile Justice Act for age determination. We know and we have read that that is the ossification test. Other tests can be performed, but the one mentioned in JJ Act is the ossification test. So, again, important to be remembered. An aspect of JJ Act is the introduction of the definition of heinous offences, and it simply means offences for which the minimum punishment is 7 years or imprisonment up to not less than 7 years. The reason I feel that this is important, because the next section that we deal with, or very often when you deal with questions from JJ Act, this, because it defines a certain class of offenses, can be a question that can be asked for you. So the definition is quite simple. It is an offense where punishment of a minimum imprisonment of 7 years or more is involved. This is another section which is of extreme importance. It states or it deals with the preliminary assessment into heinous offenses, as we just saw, by the board. What happens where a child has committed a heinous offense? In case of a heinous offense alleged to have been committed by a child who has completed or is above 16 years of age. So it deals with a particular class of children, those who have completed 16 years of age. The board shall conclude a preliminary assessment with regard to his mental and physical capacity to commit the offense, ability to understand the consequences of the offense, and the circumstances in which he allegedly committed the offense, and may pass an order in accordance with the provisions of subsection 3 of section 18. Now, what does this say? I have provided that particular subsection for ease. It says that where the board, after this assessment under section 14, which we are reading, can pass an order that there is a need for trial of the said child as an adult. So here the child is below 18 but has completed 16 years. After their assessment of his physical and mental ability, their ability, his ability to understand the consequences of his actions and so on, the court may decide that such person needs to be tried as an adult, and they may ask for the or may order the transfer of the trial to the case to a children's court having jurisdiction to try such an offense. So another important aspect to remember, assessment is done on the basis of assessment of whether he has the capacity or not, and the understanding, if it comes to a conclusion that he must be tried to as an adult, he must be then transferred to a children's court having jurisdiction for such offenses. This is one half. The other half is provided that for such an assessment, the board may take help of psychologists and psychosocial workers or other experts. So, for determining whether he should be treated as an adult or not, or the way they must deal with a child of such an age committing such an offense, they can take help of experts. And for the purpose of this section, it is clarified that this assessment is not a trial, but simply is an assessment of the capacity of this child to commit and understand the consequences of the alleged offense. Right? Where the board is satisfied on preliminary assessment that the matter should be disposed of by the board, then the board shall follow the procedure as far as may be for trial in summons case under the CRPC, provided that the order of the board to dispose of the matter shall be appealable. So an appeal can be made, provided further that the assessment under this section shall be completed within the period specified under section 14. For our understanding, for this session, all we simply need to remember is that where a child has completed 16 years, has been involved in a heinous offense, an assessment will be done by the board on what? On mental and physical capacity, on the ability of this child to understand the consequences of the offense and the circumstances in which the offense were committed. And on the basis of that, what is the most important thing that comes out is they can be tried as adults. If that decision is reached to, the case is transferred then to the children's court having jurisdiction. Right? This aspect is of most importance because it is now treating a child as an adult. When we look at some of the questions that come in relation to this, one question that has come in is, where after inquiry under section 15 of the JJ Act under 2015 is satisfied that the child is above 16 years, has committed a heinous offense and should be tried as an adult, it may commit the case of the Sessions Court concerned for trial of the child as an adult, try the child as per the procedure provided in CRPC, return the charge sheet to the investigating officer for presentation in the court concerned, transfer the case to the children's court for trial of the child as an adult. So these kind of questions are asked to you because again this is a unique feature of the Juvenile Justice Act. It is made for children, it is providing relaxations for children that commit offenses, but then there are certain sections, there are certain provisions which deal with them as adults, and then naturally the chances of these being asked in your papers become higher. So understanding 15 and 18 clause 3 together will help you understand the fact that if the child is treated as an adult, the case is transferred to the children's court after an assessment is made by the board. I hope students this short aspect is understood by you. We will continue our discussion on the Juvenile Justice Act and different aspects in another session. For today, a quick recap is that we started with understanding what is the meaning of the term child and child in conflict with law. There can be questions that come on it. As we saw, there was one question which was a type of situational question that was asked to you. Then we understood that general principles are another important aspects which are dealt with under section 3. Again, questions have been asked on the same. Then we looked into the aspect of what are the hierarchy of documents which are necessary if you're trying to determine a particular age of the individual, and that has been provided under section 94 and has been used to ask questions previously. And lastly, we also looked into the aspect of where a child who is 16 years of age or more can be treated as an adult and what can be the questions asked in relation to this particular topic. I hope you found this useful, students. We will continue in one more session for Juvenile Justice Act. I hope that you also are looking into the BNS PYQ series. There are several playlists available on our YouTube channel. I hope that you look into them and use that for your studies, for your preparations, for your exams. Thank you so much, students. Have a great day ahead.